So this is part 6 of company law problems and solutions. So the first topic here what we are going to discuss is related to articles of association. So the problem, a company at its extraordinary general meeting passed a resolution altering its articles and vesting in the board of directors blanket power to call upon any one or more members where the board was of the prima facie view that the act or conduct of such a member or members were prejudicial to the interest of the company to transfer his or her shares to such other members as may be nominated by the board in that behalf. Discuss the legality of such an alteration. So, solution, such an alteration may be declared by the tribunal on a petition by aggrieved party as illegal and ultra vires if not found to be bona fide. Now, the next problem. The directors of a company had power to borrow money up to 20,000 rupees without the consent of the members in general meeting. The directors themselves lent 40,000 to the company and took debentures. Is the company liable for 40,000? Here, the company is liable only to the extent of 20,000 because that was only the power given to the directors of the company to borrow money. So, beyond that 20,000, the company is not liable. Now, a company in which the directors hold majority of the shares altered its articles so as to give power to the directors to require any shareholder who competed with the company's business to transfer his shares at their full value to any nominee of the directors. S had some shares in the company and he was in competition with the company. Is S bound by the alteration? So here we have a case law, that is Mallison versus National Insurance and Guarantee Corporation, 1894. Mallison versus National Insurance and Guarantee Corporation, 1894. The power of the members to affect the alteration in the articles by passing special resolution is limited inasmuch as the alteration must be bona fide and in the interest of the company. In the given problem, alteration requires taking over the shares of only those who competed with the company's business. Therefore, empowering the directors to take over shares of such members seem to be in general interest of the company as a whole and hence shall be valid. S shall be held bound by alteration. Alteration binds members in the same way as original articles. The provisions of section 10 providing that the articles shall bind the company and the members to the same extent as if they had been signed by the company and by each member means the article were as originally framed. So even after the alteration, the effect is that there was no alteration made and the present article is what it was in the original place. That is the effect of alteration. So, or as they may from time to time stand after they have been altered are valid under provisions of the Act. There is a clear power to alter the articles and as altered they bind members just in the same way as did the original articles. So they are treated at par with the original articles. Now, articles of a limited company state that A shall be the law officer of the company and shall not be removed except on the ground of the proved misconduct. The company removed him even though he was not guilty of misconduct. State whether company's action is valid or not. So this case law was also discussed under section 3 capital A, that is in the second part of company law problems and solutions. So it was also discussed in part 2 of the discussion. Now here we have a relevant case law, that is Ellie versus Positive Government Security Life Insurance Company. Ellie versus Positive Government Security Life Insurance Company, 1876. In the above case, the articles of a company contained a clause that Ellie would be the solicitor of the company and would not be removed except for misconduct. He became member in the company also. He acted as solicitor of the company, but the company removed him. He brought an action against the company for breach of articles. His suit was dismissed. Now, why? The court held an outsider to whom rights purport to be given by articles in his capacity as such outsider, whether he is or subsequently becomes a member, cannot sue on the articles to enforce those rights. So the court held an outsider to whom rights purport to be given by article in his capacity as such outsider, whether he is or subsequently becomes a member, cannot sue on those articles to enforce those rights. The company has the right to amend its articles. Company is not liable for breach because articles do not confer any right on outsiders. An outsider cannot take advantage of the articles to found a claim thereon against the company. Even a member enjoying certain rights in a capacity other than a member cannot enforce them against the company. So that was held in LE versus Positive Government Security Life Insurance Company. So it is to be noted the articles of association had a clause that a particular person was to be appointed as the law officer. He can be removed only based on proved misconduct, but he was removed though it was not proved misconduct. So was this act valid? That was the problem. So the court held that that is valid. A third person cannot, an outsider cannot enforce any right based on the articles of the association. Articles can be altered at any time. So, and the relevant case law here is LE versus Positive Government Security Life Insurance Company. LE versus Positive Government Security Life Assurance Company. Now the next problem. The articles of a company provided that the shares of a member who became bankrupt would be offered for sale to other shareholders at a certain price. Is this provision binding on shareholders? So here we have another case law, that is Borland Trustee versus Steel Bros and Company Limited. Borland Trustee versus Steel Bros and Company Limited, 1901. In this case, the provision in the articles were held to be binding on the members. The court observed that shares having been purchased on these terms and conditions, it is impossible to say that those terms and conditions are not to be observed. Thus, since articles constitute a binding contract between the company and its members, the shareholders shall be held bound by the stated provisions in the articles. We have another question. The plaintiff contracted with the director of the defendant company and gave him a check under the contract. The director could have been authorized under the company's articles, but was not in fact so authorized. The plaintiff had not seen the articles. The director misappropriated the check and the plaintiff sued the company. Is the company liable? So here we have relevant case law as Rama Corporation versus Proved Tin and General Investment Company. So Rama Corporation versus Proved Tin and General Investment Company. The problem relates to the protection that the outsider may claim against lack of authority on the part of the officers of the company. The rule commonly known as the doctrine of indoor management was first laid down in the case of the Royal British Bank versus Turquent, also known as the rule in Turquent case. However, it has been held that the rule of indoor management cannot be invoked in favor of a person who had no knowledge of the articles of the company. It is because in such a case, the person cannot assume that the power of which he has no knowledge has been rightly exercised. So it is to be noted that though we do have doctrine of indoor management laid down by the Royal British Bank versus Turquent or rule in Turquent case, though we have doctrine of indoor management, the court held it has been held that the rule of indoor management cannot be invoked in favor of a person who had no knowledge of the articles of the company. It is because in such a case, the person cannot assume that the power of which he has no knowledge has been rightly exercised. So in Rama Corporation versus Proved Tin and General Investment Company, the plaintiffs contracted with the defendant company and gave a check under the contract. The director could have been authorized but in fact was not. The plaintiff had not read the articles. The director misappropriated the check and the plaintiff sued. Held the director not liable as it was outside his authority. So if the defendant had known the articles of association and if he was of the bona fide belief that all the indoor processing or the inside processing of the company was met and upheld, then the doctrine of indoor management could have been applied. That is also known as the rule in Turquent case. Now, in Rama Corporation versus Proved Tin and General Company, it was held that the plaintiffs could not rely on the rule of indoor management because they did not know the existence of the power to authorize the director. Here the rule of doctrine of indoor management was not applied because the plaintiff did not know the existence of the power to authorize the director. He was not aware of the articles of the company, articles of association of the company. That's why. In the present problem, company shall not be held by the act of the director who has transacted beyond the scope of his authority. A principal can be held liable for the frauds of his agent only to the extent they are committed within the scope of the authority conferred upon him. So with this, next we have doctrine of indoor management. So the secretary of a company issued a share certificate to A under the company's seal with his own signature and the signature of a director forged by him. A borrowed money from B on the strength of this certificate. B wanted to realize the security and requested the company to register him as a holder of the share. Explain whether B will succeed in getting the share registered in his name. So here the doctrine of indoor management is applied, and the relevant case law landmark judgment in which doctrine of indoor management was laid is Royal British Bank versus Turquent. That is in 1856. Royal British Bank versus Turquent. In this case, the director of the Royal British Bank also gave a bond to T. The article empowered the directors to issue such bonds under the authority of a proper resolution. In fact, no such resolution was passed. Notwithstanding that, it was held that T could sue on the bonds on the ground that he was entitled to assume that the resolution had been duly passed. Thus, the person dealing with the company are entitled to assume that the acts of the directors or the officers of the company are validly performed if they are within the scope of their apparent authority. But this doctrine is not applicable where the person dealing with the company has notice of irregularity, or when the person dealing with the company is put upon inquiry, or when an instrument purporting to be enacted on behalf of the company is a forgery. So what are the exceptions of doctrine of indoor management? That is, cannot be applied when the person dealing with the company has notice of irregularity. That is the first condition. The person dealing with the company has notice of irregularity. Or where the person dealing with the company is put upon inquiry. That is the second condition. And the third condition, when an instrument purporting to be enacted on behalf of the company is a forgery. So in these three scenarios, the doctrine of indoor management cannot be invoked. And through case law, we also have seen that the doctrine of indoor management cannot be applied when the plaintiff party had no knowledge of the articles of association or the authority of the directors. Now, doctrine of indoor management. The doctrine of indoor management is an exception to the rule of constructive notice. The rule of constructive notice throws a burden on the people entering into contracts with the company that they are presumed to have read the documents, though in fact they might not have read them. On other hand, doctrine of indoor management allows all those who deal with the company to assume that the provisions of the articles have been observed by the officers of the company. They are not bound to inquire into the regularity of the internal proceeding. So the key word here with respect to doctrine of indoor management is the person entering into a contract, they are not bound to inquire into the regularity of internal proceedings. Regularity of internal proceedings is the keyword here. An outsider is not expected to see that the company carries out at its internal regulation. So that was laid down by Royal British Bank versus Turquent, also known as the rule in Turquent's case. Now, the rule of constructive notice seeks to protect the company against the outsider. The doctrine of indoor management operates to protect the outsiders against the company. So they both act in two opposite sides. That is, the rule of constructive notice is to protect the company against outsiders, and the indoor management is to protect the outsiders from the company. So what is said in constructive notice is that the person who is entering into a contract with the company, they are presumed to have read the documents, because all the documents, all the relevant documents of the company is available with the public authority, which the person entering into the contract can avail by due process. So they are presumed to have read that. Whether they have read or not read in real, they are presumed to have read the documents. So that is with doctrine of constructive notice. It protects the company against the outsider. Whereas doctrine of indoor management is to protect the outsiders from the company. The outsiders shall have an idea of the documents and the articles of the company, but the outsiders are not to get into the regularity or the internal proceedings of the company. they will presume that all the articles of the company has been met by the officers of the company. That is presumed by the outsiders, and that is discussed in doctrine of indoor management. And the principle of doctrine of indoor management was laid down in Royal British Bank versus Turquant, that is in 1856. This doctrine is also known as rule in Turquant's case. Now, the memorandum and articles are public documents and are open for public inspection. Hence, an outsider is presumed to know the constitution of the company, but not what may or may not have taken place within the doors that are closed to the public in general. That is discussed with indoor management. The doctrine of indoor management, which is popularly known as Turquant's rule, is very useful and important. However, there are certain exceptions to this doctrine, and the doctrine is not applicable under the following circumstances. So now, again, we are going to look into the exceptions in doctrine of indoor management. So the first one is knowledge of irregularity. So, the first and the most obvious restriction is that the rule has no application where the party affected by an irregularity had actual notice of it. So, knowledge of an irregularity may arise from the fact that the person contracting is himself a party to the inside procedure of the company. If such person, who is himself a part of the internal machinery, cannot take advantage of the doctrine of indoor management. And here we discuss about Howard versus Patent Ivory Company. We already discussed this earlier. I believe the facts is as such that there was a prospectus, and the person knew that there was issues with the prospectus, and later he didn't buy the shares with respect to the prospectus, but later bought it from an open share market, and then moved to the court for a remedy, stating that there was misstatement in the prospectus, and the court said that that is not possible. One, the person was aware of such a irregularity, and then he did not buy the shares through prospectus, but he bought it in a open share market, so he is not a direct LOT. So in that scenario, we did discuss about Howard versus Patent Ivory Company. I believe this is the fact. So the same is applied here. So the knowledge of irregularity, if the person knew that there was an irregularity and still did move forward with it, then the person cannot claim the doctrine or remedy under doctrine of indoor management. Now, it is not just knowledge of irregularity. The second exception is that suspicion of irregularity. Even the suspicion matters. So, the protection of Turquant rule is not available where the circumstances surrounding the contract are suspicious and therefore invite inquiry. Suspicion may arise from the fact that an officer is purporting to act in a manner which is apparently outside the scope of his authority. So, when a person is acting, or when an officer of the company is acting outside his authority, which creates a genuine suspicion that he is acting outside his authority, then it is the duty of the person who is entering into the contract to look into the genuineness of it to ensure there is no irregularity. So, where, for example, the plaintiff accepted a transfer of a company's property from its accountant. So, it is obvious that an accountant cannot transfer the company's property. That is outside the scope. So, the transfer was held void, and this was discussed in the case of Anand Bihari Lai versus Dinshaw Company. That is, here a person who was the accountant in the company transferred a part of the company's property. So, for a third person, it was obvious that this is outside his scope, and yet moved forward with the transfer. So, that is where it's an exception to indoor management, because there was a suspicion of irregularity, and this case is Anand Bihari Lal versus Dinshaw and Company. Now, in Anand Bihari Lal versus Dinshaw and Company, the plaintiff accepted transfer on the company's property from its accountant. The transfer was held to be void because such a transfer is apparently beyond the scope of the accountant's power. It puts the person dealing with the company under inquiry. The plaintiff should have insisted on seeing the power of attorney executed in favor of the accountant by the company. Even a delegation clause is not enough to make the transaction valid. Please note, even a delegation clause is not enough to make the transaction valid unless the accountant is in fact authorized. Now, the third exception is forgery. Illegality such as forgery will exclude the Turquoise rule. The doctrine of indoor management applies only to irregularities which might otherwise affect the transaction, but it cannot apply to illegality such as forgery, which must be regarded as nullity. So this was held in Rubin versus Great Fingal Consolidated. Rubin versus Great Fingal Consolidated. Now the fourth exception, no knowledge of memorandum and articles. So this also we discussed earlier. If a person doesn't know the power of a officer or a director or the scope of his authority, he cannot claim for doctrine of indoor management. So the fourth exception is that no knowledge of memorandum and articles. The rule cannot be invoked in favor of a person who did not consult the memorandum and articles and thus did not rely on them. And this was again held in Rama Corporation versus Proved Tin and General Investment Company. Rama Corporation versus Proved Tin General Investment Company. Now the fifth exception is that acts outside apparent authority. So it can be discussed the same with Anand Bihari Lai versus the insurance company. That is, we can use the same case law here. That is an accountant transferring company's property. So acts outside apparent authority. If the act of an officer of a company is one which would ordinarily be beyond the powers of such a company and which would also ordinarily be beyond powers of such an officer, the protection of the Turquoise rule cannot be claimed. Now the last exception, the sixth exception to the doctrine of indoor management is doctrine is not applicable where a precondition is to be fulfilled before company itself can exercise a particular power. Here that is, a precondition is to be fulfilled before company itself can exercise a particular power, and that is discussed in Pacific Coast Mines versus Arbuthnot. Pacific Coast Mines versus Arbuthnot. In this case, it is stated that the memorandum of association and articles of association are the constitutions of the company and is not is not a public and is a public document. Further, any person entering into the transaction is presumed to be aware of it, but he does not need to know about the things that are happening within the doors of the company. So what was held here is the memorandum of association and articles of association are the constitution of the company and is a public document. Further, any person entering into the transaction is presumed to be aware of it, but he does not need to know about the things that are happening within the doors of the company. So the person shall know about what are the preconditions laid down by memorandum of association and articles of association. That doesn't mean that he has to look into what is happening inside the closed door. So that is with doctrine of indoor management, and there is 6 exceptions to indoor management. The first one is knowledge of irregularity, second one suspicion of irregularity, then the third one is forgery, fourth one is no knowledge of memorandum and articles, the fifth one is acts outside apparent authority, the sixth one is doctrine is not applicable where a precondition is to be fulfilled before company itself can exercise a particular power. And the relevant case laws that was discussed is Royal British Bank versus Turquoise. That is the rule in Turquoise case. Now Howard versus Patent Ivory Company. Now the next one is Anand Bihari Lai versus the insurance company. Then we have Rubin versus Great Fingal Consolidated. Then Rama Corporation versus Proved Tin and General Investment Company. And then Pacific Coast Mines versus Arbuthnot. So these are the relevant case laws with respect to doctrine of indoor management or the rule in Turquoise case. Now we have a few more problems with respect to the doctrine of indoor management. The next one, while the doctrine of constructive notice seeks to protect the company against the outsider, the doctrine of indoor management operates to protect the outsider against the company. Explain. We already did discuss this. So while the doctrine of constructive notice seeks to protect the company against the outsider, the principle of indoor management operates to protect the outsider against the company. According to this doctrine, as laid in Royal British Bank versus Turquoise, that is the doctrine of indoor management. Persons dealing with a company having satisfied themselves that the proposed transaction is not in its nature inconsistent with the memorandum and articles are not bound to inquire the irregularity of any internal proceeding. In other words, while persons contracting with a company are presumed to know the provisions of the contents of the memorandum and articles, they are entitled to assume that the provisions of the articles have been observed by the officers of the company. It is not part of the duty of an outsider to see that the company carries out its own internal regulations properly. Now, the next problem we have here is the Articles of Association of XYZ Limited provides the Board of Directors has authority to issue bonds provided such issue is authorized by the shareholders by a necessary resolution in the general meeting of the company. The company was in dire need of funds and therefore it issued the bonds of Mr. X without passing any such resolution in general meeting. Can Mr. X recover the money from the company? Decide referring to the relevant provisions of the Companies Act 2013. So, according to the doctrine of indoor management, if an act is authorized by the articles or memorandum, an outsider is entitled to assume that all the detailed formalities for doing that act have been observed. As per the case of Royal British Bank versus Turquent, the directors of the Royal British Bank Limited gave a bond to T. The articles empower the directors to issue such bonds under the authority of a proper resolution. In fact, no resolution was passed. Notwithstanding that, it was held that T could sue on the bonds on the ground that he was entitled to assume the resolution had been duly passed. This is the doctrine of indoor management, popularly known as the Turquent rule. Since the given question is based on the above facts, accordingly, here in this case, Mr. X can recover the money from the company considering that all the required formalities for the passing of the resolution have been duly complied. Now we have another question with respect to doctrine of indoor management or Turquent rule. Now, the common seal of company has been affixed by the company on a document without the compliance with the provisions of the Companies Act. Does this affect the validity of the document? The solution: the outsiders will be protected on the ground of doctrine of indoor management. Now, another problem. The director of a company borrowed 10 lakh from Tarun. They had the power to borrow such money, but only subject to the ordinary resolution passed at the general meeting of the company. In fact, no such resolution has been passed. Is the company bound to repay the loan to Tarun? Give reasons. Here again, we can use the same case of Royal British Bank versus Turquent. The facts are more or less similar. Here, yes, Tarun is protected by the doctrine of indoor management. And the next problem we have here is the articles of a company empower the directors to determine who should have the authority to draw bills on behalf of the company. C. The manager of a branch of the company drew bills on behalf of the company in favor of K, who took them in good faith believing that C was authorized to draw them. In fact, C had no such authority. Is the company liable on the said bill? Will it make any difference if C had been a director of the company? So, here, yes, the company would be liable in both the situations on account of the doctrine of indoor management. So, the next problem is the secretary of a company issued a share certificate in favor of Mr. Cook, which apparently complied with the company's articles as it is purported to be signed by two directors and the secretary, and it had the company's seal affixed to it. In fact, the secretary had forged the signature of the directors and affixed the seal without authority. Is the certificate binding on the company? So what happened here is it is forgery. The company's seal and the signatures were forged. So the company is not bound by the forgeries committed by its officers. The doctrine of indoor management is not applicable to forgeries committed by the employees of the company. This is because the doctrine regularizes the irregularities and not the illegalities. It is to be noted the doctrine of indoor management is used to regularize the irregularities and not the illegalities. Forgery is illegal and therefore void ab initio. And the relevant case law here is Reuben versus Great Fingal Consolidated Limited. Reuben versus Great Fingal Consolidated Limited. The secretary of the company forged the signature of two directors and after affixing the seal of the company issued it to Reuben. The company denied the certificate. The plaintiff contended that he had no means to know whether the signature are genuine or forged, and therefore it is part of internal management of the company. But it was held that the rule of internal management has never been extended to a forgery. So that is with doctrine of indoor management, and end of this part. We still have a lot of problems to discuss, and that will be continued in the following parts. Stay tuned, and thank you for listening. There is a small correction. Howard versus Patent Ivory Manufacturing Company. The facts of this case is that where there is a pre-incorporation contract and the company has executed a new contract after the incorporation, the pre-incorporation contract stands discharged, and according to the new contract, the liabilities of the promoters the company becomes liable for any further action, and the liabilities of the promoters come to an end with the discharge of the pre-incorporation contract. So that is the facts of the case, or the decision in the case of Howard versus Patent Ivory Manufacturing Company. So there was a small correction. So the knowledge of irregularity here discussed with Howard versus Patent Ivory Company. The main decision in Howard versus Patent Ivory Company is that when a contract, a pre-incorporated contract exists, and after the incorporation the company executes a new contract, the pre-incorporated contract stands discharged, and with the discharge of the pre-incorporated contract, the liabilities of the promoters also come to an end. So that is the decision that was held in Howard versus Patent Ivory Company.